Ms. Lucey, you may proceed.
May it please the court. My name is Martha Lucey. I'm here today representing Jesse Gaskins. Iowans have generally enjoyed a greater degree of liberty and equality because we do not rely on national consensus regarding fundamental rights without also examining new understandings. That's not an original quote. That's from Justice Cady. There's two main issues that this court needs to decide in Mr. Gaskins' case. The first issue is whether Arizona versus Gant is consistent and compatible with the Iowa Constitution, Article 1, Section 8. Arizona versus Gant does not require probable cause to search a vehicle under the evidentiary rationale in a search incident to arrest case. The second issue is whether or not the automobile exception should be maintained and is compatible with the Iowa Constitution, Article 1, Section 8. This is a relatively...
Counsel, to what extent is the automobile exception even really before us? As I read the record on the motion to suppress, the only thing asserted as a justification for no warrant was the search was incident to an arrest. And that appears to me to be the only exception that the district court addressed. And so why are we even looking beyond that in this case?
Well, I think that if you find that it's not a search incident to arrest, then you need to go to that next step. Is there another exception that would uphold this ruling?
Even if it's not asserted by the state?
You know, I think prior cases certainly say that, yes. In State versus Vance, there was a dissent that indicated, well, why are we preserving this for post-conviction relief if there is this other viable potential exception? I think the other difficulty...
That was a dissent, but let me ask you this too. Is this search even good under the federal Constitution? Because what we had is a locked safe, as I understand it. And the search incident to arrest doctrine does generally allow, within a compartment of an automobile, a search. And here, a locked safe was uncovered. It's kind of like the trunk of the car. Would under federal law the safe be subject to search? It doesn't have wheels. It isn't going to drive away. The police can hold it and get a search warrant. So do we have to even address the Iowa Constitution?
I think you do, Your Honor, because my reading of Ross and, it begins with an A, anything in the
Acevedo?
Acevedo, anything in the passenger compartment, locked, closed, it's all fair game. They have made no distinction. This is a van, so there is no trunk. Under normal circumstances, how would someone transport a weapon legally, forget about being loaded, an unloaded weapon legally in a van?
Well,
they have to be in a container.
Justice Scalia, in his last couple opinions, has focused on the underlying rationale for Belton originally. And Belton originally was based in part on safety. And Justice Scalia in Gant said that the safety concerns were really not appropriate, needed to be shaved back. And then the question on search incident to arrest is the possible destruction of evidence. But of course, if we have a locked case in the back of the trunk, there's going to be no destruction if the police officers pick it up and take it to the station, much as occurred in the Chadwick case. That's the Foot Locker case. And the Foot Locker was, the FBI held the Foot Locker, and the requirement was get a warrant. Isn't the logical solution here simply for police, they can search the inside of the compartment. When they find something that's locked, a locked safe, they just hold it and go get a warrant.
I totally agree with you. Unfortunately, I don't believe the U.S. Supreme Court does.
Well, you've got some filaments of it. You've got the Chadwick case that says that the
Chadwick's
Foot
been
Locker.
overruled by Ross.
Well, but then you've got Scalia coming back and saying, well, you've got to look at the underlying functions of the exception, and there's not going to be any loss of evidence in a locked case that's being held.
I completely agree with you. I just don't think that that's what the federal courts have held at this point in time.
So, Counsel, you're, for that reason, relying on the Iowa Constitution, and much of the state's brief in this case, and I believe it's the first opportunity the state's had to present this argument, they're asking our court to adopt a set of neutral interpretive criteria for deciding when or under what circumstances we should decline to follow federal decisions interpreting identical language in the state constitution. What's your position on, is that a good idea? And if not, why not?
There's a couple different things. One, I would frame the issue differently. Should the court adopt guidelines or factors to be used in evaluating or analyzing the Iowa Constitution? Yes. But those factors don't have to be about divergence or departing. It would be normal factors, which this court has already adopted in Klein. Klein has factors.
Sure, in fact, and all the so-called criteria states, Washington, New Jersey, Pennsylvania, they're all non-exclusive anyway.
Correct. And I don't think we should have exclusive ones because there are certain cases that are never going to lend itself to certain factors. One of the law review articles that the state cited in its brief talks about it can't be the magic key to the kingdom. And I would agree with that. Are there factors that should be applied in analyzing any constitutional issue? Certainly. Should you lay out some of these factors? Yes. I think you already have in Klein, which was reinforced in Short. Even though there's not a particular method that you have to do 1, 2, 3, or 4, there are factors that are looked at and considered. My disagreement is how the debate is framed and maybe some of the tone of the debate. I don't think that there needs to be factors to divert or diverge. I keep saying divert, and that's not exactly right. Diverge, because we have two sovereigns. So they would be like saying, okay, we're going to have factors why we're not going to include, we're not going to consider UN rulings. We have two sovereigns. There should be independent factors for each analysis. And I don't think there's any disagreement that there could be factors, and there are factors. And maybe what this court could do is reaffirm that the factors outlined in Klein are factors that should be raised below.
Well, these factors are
briefed.
outlined in all of our cases. I mean, do we look at the constitutional history to the extent there is any? Of course, there's very little state constitutional history. On search and seizure in particular, there's almost no meaningful United States constitutional history. There's a lot of common law, and that's all contained in ACOA and Baldwin and Short. But as Tony Amsterdam told us 30 years ago, the language and history of search and seizure is not going to get us too far. And as Justice Scalia told us in Gantt, there's plausible interpretations of search and seizure that include Rabinowitz, which I think is extraordinary. I like Justice Frankfurter's dissent. And then there's Kymel, which is much narrower and more consistent with Short. Open-textured provisions of constitutions have propose or allow wide choices, and that's why we have judges rather than checklists.
And I do disagree with the state's assertion that it has to be raised below or you can never address it. Well, then we might as well just get rid of ineffective assistance and maybe go to plain error, which I'm not sure is any better because it still hasn't been raised below. Could this court help trial lawyers by maybe giving them very...
Have you read?
I don't understand that statement. Why couldn't it be raised below? Why couldn't it?
Oh, it could have been, it just
defense
wasn't.
lawyer? I mean, you say it couldn't be. It could have been, right?
Oh, I think maybe I misspoke, Justice. I don't think I meant to say it couldn't have been. But I'm saying that if this court is never going to look at claims of ineffective assistance because it was not raised below, then is that special for Iowa constitutional issues?
No, that's
I
not
would
our
submit,
law.
no, we
But,
shouldn't.
but frankly, if there's factual matters that could have been developed below, of course, we've got a major league problem. We're gonna put them off to the
Certainly.
PCR, and I don't think you necessarily disagree with that.
No. And would I like trial lawyers to raise all these things? It would be wonderful. I might actually get to have a vacation on occasion and take weekends off. It would be great. But I think that some of the criticism may be constructive on how do we go about doing this. And I think we just go back to Klein and say, we told you how to do this. We haven't really changed it, but maybe we're not using the headings that say textual difference. You know,
Well,
Counsel, I want to get back to this case in particular and find out a little more about your position on locked containers. Is it your view that there should be a bright line rule that if it's a locked container, you need a warrant?
I don't think that's actually what I said in my briefing, and I don't think it would be fair to come in here and say I did say that. My position is that under the Iowa Constitution, there requires probable cause. So Justice Scalia's theory in Thornton, which was adopted by the majority in Gant, that does not require probable cause, is not compatible with this Constitution. And then the next question is, if there is probable cause, should the exigent circumstances be the fact that it's in a vehicle that has wheels and could be theoretically driven away at some point in time, be enough to justify that further intrusion? And I would submit to this court that the answer should be no. And so should it be the fact that it's a locked container within this car? That maybe is one of those factors that would go into the whole analysis of the exigent circumstances. But I don't think it would be fair for me to get up here and say that that's what I argued, because I don't think that's what I argued. And to answer your question earlier about preservation, when you look at what the state argued, what the defense argued, and what the judge ultimately decided, it seems like they're talking about search incident to arrest, but they use probable cause on occasion. So is it sort of both decided? And if there is no justification for the search incident to arrest under Gant, which I would submit under the Iowa Constitution there should not be, then do you go farther? Do you send it back for PCR to continue on this discussion and give the state a second bite? Is there a possibility that this could be an inventory search at some point in time? The officer talks about, oh, I was going to have the car towed incident to arrest. Well, I'm not quite sure what that means, but inventory searches in impoundment require a specific policy. None of that was introduced, but a fair reading may actually show probable cause actions and circumstances, and that's why I briefed it. Does that help?
So I understand your position on probable cause, and on exigent circumstance, what in your view does law enforcement need to show in order to establish an exigent circumstance, and why wasn't that here?
Here, the only thing that was shown was the fact that the vehicle was movable. That's it. I think that in my brief I talk about other cases and
What does the
other
record
possible.
show about the safe?
About the safe. You could pick up the safe and go. I mean, I think the evidence was it was maybe a pound or two, unclear because it was this big. The record doesn't say what that big is. There's no pictures of it. It could be safeguarded, but so can the car. I'm not sure that.
What if, you know, they impounded the car? Then you got an inventory search that's gonna find it anyway.
But there's normally some type of policy rationale that needs to be shown. This is why we impound cars, to support that inventory search.
But even an inventory search, I guess they could take the safe out and not open it without a warrant.
They wouldn't need to, but I mean, what's the difference between that locked safe and, you know, maybe the locked glove compartment or the console? You're still trying to say, this is private, you can't get in here, I'm not inviting you to come look. So I think that the locked safe adds that extra element, Under federal law, it adds no element. Under Iowa Constitution, maybe it adds an element. I'm going to run out
So
of time.
under the Iowa Constitution, in your view, if the safe was unlocked, search okay?
Depending on other circumstances.
Other
I
circumstances?
think it goes into the whole exigency analysis that is, I see my time is up, may I finish? Is there some indication that this evidence may disappear? Is there some indication that there is something in this compartment that is dangerous? Can I not get a warrant for it because it's impractical and I just don't feel like it today? That's not okay. But I think that goes into the factors. But when you start talking about expectation of privacy, if I lock something, I don't really want you to go in.
So if a safe isn't locked, it's not really a safe. It's just a box that you can open up.
I wish we knew what the safe looked like, and I have in my mind what it does look like, which does look like a box with a top that has a lock.
Well, we know it was apparently small enough to fit under the seat.
Correct, and maybe weighed a
So-
couple pounds, and I believe, I want to say that record says that it was fireproof.
And the key, there was a key, and the
A
key
key.
was on the ignition keychain, if I remember
Yeah.
right.
Which they conclude was next to his home key, but I'm not quite sure where that conclusion comes from either.
But the bottom line is the safe was locked and could have been held while the search warrant was obtained without sacrificing safety or destruction of evidence.
I agree with, in this case, that is certainly the case, and I would submit that the van was the same thing. The rest of the van, even though they didn't find anything more in the van, but that van was, there's no indication that that van was going to move away when its driver was arrested.
And put in the squad car
Squad
away
car.
from the car.
And taken to the jail and booked. There's no indication that that van was going anywhere. And if they were concerned about the safe not being safe in the vehicle that they've left, they could take it with them, just like they did in Chadwick. And I think the Chadwick rationale is certainly logical. And I'm way over my time. I'd ask this court to reverse the district court and suppress the evidence. Thank you.
Thank you as well, counsel. Mr. Buller.
May it please the court. Good afternoon, your honors, counsel. Today, this court's being asked to abolish the automobile exception and to overturn more than 35 years of this court's own case law.
Well, we're not being asked to abolish it, actually. We're asked to tighten it up. And the tightening it up would simply be this. Automobile exception, actually, it's been recognized, even at common law, I think, prior to our Constitution. Where there is a risk of the vehicle actually leaving, and where there's a risk to officer safety that you can clearly search. So the automobile exception is still going to exist because it's based on the inherent mobility of the automobile. And all of our cases talk about the inherent mobility of the automobile. This is a safe case. The locked safe can be taken out of the automobile. It's not inherently mobile. It won't fly away, the safe itself. If the safe is simply put in the squad car, there's no risk to officer safety. And I will tell you, officer safety is a big deal, I think, in the cases. And Terry is right. And, you know, if there's a risk to officer safety, by all means, you know, look first, ask later, no question. And if there's a risk of destruction of evidence, that can be a significant factor. But here, there's an easy way out. Grab the thing, get a search warrant, and if you have probable cause, in you go. So we're not asking to abolish the automobile exception, but we are asking, or they are asking, to tailor it and narrowing it to meet the underlying purposes of it. That's not a revolution. But why don't you address those points?
Your Honor, I think I read the defendant's argument differently. In the briefing, the defendant says that the automobile exception is not compatible with the Iowa Constitution. That's what I perceive as a full frontal attack on the automobile.
Okay, fair enough. But we don't have to go that far to get to the result, I don't think.
I want to pick up on something else you mentioned. This is really a case about a safe. I don't believe that's true at all. That is absolutely not the argument in front of this court. That was not the argument at the district court. The safe's really not discussed at all in the briefing.
The automobile exception discussed in the district court?
No, Your Honor, and there's a weird puzzle to that issue. And here's where I'm coming from on that the Gantt evidentiary rationale for a search, that is the automobile exception. And the reason for that is because it takes probable cause plus exigent circumstances, and that gets you to a warrantless search. That's what the automobile exception is. And that's what the state's position is on the evidentiary rationale under Gantt. Officer safety be different. There we're talking about something lesser than probable cause, probably reasonable suspicion. But with probable cause in the search of a vehicle, we're talking about the Carroll Chambers automobile exception.
Where's the probable cause in exigent circumstances to open the safe when it could have been removed from the car?
Like my friend from the appellate defender's office said, once you're into the vehicle for probable cause of search of a vehicle, under the federal constitution, to all of the containers. That's what Ross and Acevedo say, because Chadwick does not apply to the interior search of a car under the automobile exception. If the defendant's argument was that this court should, I guess, bring back Chadwick under the state constitution.
Well, let me back up. Where's the probable cause that there would be evidence of a further crime in the car to even search the car under Gantt?
I would direct the court's attention to State versus Watts. In that case, this court recognized that the majority rule in other jurisdictions is that the smell of marijuana alone is probable cause. This court didn't quite go there. The test in Iowa is something right now like marijuana plus. And we have marijuana plus in this case. The officer smelled marijuana, plus the defendant handed him a joint, plus the defendant made an admission, plus the defendant was evasive or, depending on your reading of the record, gave an untruthful statement. That's probable cause, there's no question. Under Watts, the officer had probable cause to find additional evidence of contraband. And the police officer's explanation certainly makes sense, where you have one blunt handed to you by the defendant and you smell burning marijuana. There's probably other drugs in the car. That's probable cause, a fair probability of finding additional contraband. And that gets the officer into the car. Under the federal constitution, the automobile exception applies, and there's no need to prove additional exigency. I want to pivot back to a point you made earlier, Justice Apple, about factual development. If the state had been put on notice that we needed to offer proof of additional exigency, we could have done so. But nobody knew at the district court that that's what we were talking about. This is about the most plain Jane motion to suppress you could have. It says that the search violated Article 1, Section 8 and violated the Fourth Amendment. Doesn't say why. It doesn't cite any cases. I'm not sure if I were an assistant county attorney, I'd be able to figure out what the defendant was arguing in this case.
And if that were the case, and if you are getting sandbagged on appeal, and there would have been an evidentiary showing of some kind, ordinarily we'd put that into PCR. I think, and it's a question of applying those principles, I guess. But let me invite you to set aside the cases and just argue constitutional policy to me, and that is this: in this particular case, there is a safe, and ordinarily a safe is something where people put personal effects in, and they do that for purposes of security. Or the Iowa Constitution speaks of being secure in their effects and papers and so forth and so on. So I mean, the safe is at least triggering constitutional concern, I think it's fair to say. On the other hand, I think there's no doubt in an automobile case, or maybe even any case, there's concern for officer safety, and I have already granted you that, and there's concern for destruction of evidence. And I think those two concerns are legitimate. All right, but then applying that to this case, it seems to me we can protect the constitutional interest in privacy, we can protect the concern about destruction of evidence, and we can protect officer safety by simply saying to officers, hang on to the safe and get a warrant. So come back to me on a constitutional policy level. Tell me why the state thinks that this is a bad rule for the Iowa Constitution.
Your Honor, first I would say there's no safe issue in here, but I'll grant you, hypothetically, let's say someone had raised it below and it was raised on appeal, neither of which are true here. There are legitimate officer safety concerns in how to handle a safe and a vehicle in the field. The officers in this case, it turns out rightly suspected there were drugs and guns in this car.
Wait, but Justice Scalia, talks about when you have, and maybe I have the facts wrong here, and please correct me if I do, but when you have someone in the back of the squad car dealing with public safety, he says, well, you know, gosh, you'd have to be Houdini or Hercules to get in the automobile and so forth and so on. And so in Gant, he kind of pulls the plug on safety concerns where police follow routine procedures. So how is this case outside of Justice Scalia's safety analysis?
Well, first, I'm not sure there is a routine police suspect encounter. These are very dangerous situations for
Well,
police
Justice Scalia,
officers.
I mean, I'm sorry to come at you, if you don't mind. I'm sure I appreciate our conversation here, but he says, as a matter of routine, when automobiles are pulled over, people are asked to get out of the car, and they're patted down, Terry type, pat, no doubt, and then get them back into the squad car. And gosh, he uses some pretty colorful language. He talks, kind of about the mirage of safety and so forth and so on. And I think it's fair to say that Justice Scalia generally is very sympathetic to safety concerns of officers, as I think any judge would be, quite frankly. But I invite you again. It seems to me it's fairly routine, and Justice Scalia suggests it's fairly routine to get somebody in the backseat of the car. That, in fact, happened here. So I invite you to respond.
Yes, sir. There are other things going on here. We have a passenger in the vehicle, for example. The officer wouldn't want to leave a passenger, in this case an underage girl, unattended in a vehicle with guns and drugs. That's dangerous not only for that person, but for the officer and for the community at large.
But you could have picked up the safe once it was found and taken it out. And so, I mean, I think you could search the rest of the car for guns while you're there. But here's the safe. Okay, well, we're going to hang on to that and get a search warrant. And maybe you would have got a warrant. I mean, I think your position is you had probable cause. I understand your position would have been reviewed by a magistrate fairly quickly, and once you got probable cause, you would have got in.
As a matter of pure policy, setting aside real-world concerns, I absolutely agree with you. That might be a good idea. That might be good public policy. Here's the problem. The cop had no idea he needed to do that. There's no established legal rule that required it. No one put him on notice. And the reason we need bright-line rules isn't so that we can talk about them up here at the Supreme Court. It's so the officer in the field knows what's going on. It's so that the county attorney knows what advice to give.
Well, Counsel, it sounds to me like what Justice Apple might be suggesting is a bright-line rule. If you make an arrest, as was made in this case, you've got the occupants disabled and back in the cruiser, can't get access to what's in the car, and you find a locked container, the bright line rule is you get a warrant. I mean, so why isn't that workable?
Well, it might be workable if anyone had noticed that was the law. I would even give you that a rule of get a warrant in every single case ever. That's a bright line rule because everyone knows what the rule is. But of course, that's not what the Iowa Constitution or the federal Constitution require. The driving term of both of those provisions is reasonableness.
The warrant requirement subsumed by reasonableness. I mean, tell me if you think it is, tell me why.
Subsumed is a strong word. I think you read them together. Is there a warrant preference built into this reasonable analysis? I think everyone would agree. Certainly the United States Supreme Court and this court would agree on that point. But the automobile exception is one of those well-trod, well-established exceptions that is reasonable. Because
except it's way too broad. I mean, I fear. It's reasonable where there's mobility. And I get that. I mean, it's like the sailing ships, which is what it's based on. And that's fair enough. And search incident to arrest for safety purposes and for evidentiary purposes, again, I get that. But as Scalia points out in Gant, we don't want our bright line rules to be overbroad. We want even our bright line rules we want to be reasonably well tailored. There is a police reliance interest, which he discusses and then casts aside in the interest of constitutional protections as he saw it. What is unworkable about the rule that is just being suggested? If you find a locked container in an automobile, hang on to it. That might be a seizure itself, but one that would, it seems to me, be pretty logical. You seize to get a warrant. It's pretty hard to say, well, you should have got the warrant first. I mean, that just doesn't work. What's wrong with that as a rather clear rule?
again, if this were a safe case, that might be a rule we could litigate on appeal, but that's not before us. We're talking about the automobile exception. Justice Scalia, I think in his special concurrence, makes a lot of good points, but he also has an important caveat, and that's that while he might be reining in the Belton rule, here are all of these other well-established, clear exceptions to the warrant requirement, and one of the ones he lists is the automobile exception.
But I think I think what we're saying is, I mean, the question is the scope of the automobile exception. I'm actually buying in, at least for now, arguendo. I'm buying into part of the automobile exception. But I'm saying it doesn't extend far enough to get a hold of the safe. You know, if it's a plastic bag from Walmart with whatever in it, you know, sitting on the front seat, by all means, go look at it, of course.
My answer to that is, one, I point to Ross. I say it's the clearly established rule, and the rationale there was that we're going to get into these containers anyway. One of the reasons mentioned by the court earlier is the police could just inventory the car. There's some evidence in this record that the cop planned to inventory or at least tow the car. As Ms. Lucey points out, we don't have a complete record. We don't have a policy or anything like that. But there's nothing to be gained by requiring the officer to obtain a warrant to search the safe here when he could have gotten into the safe simply by towing the car to the police station and conducting a routine inventory.
I think you're right. I think probably the inventory search doctrine would also have to be parallel to the automobile exception, which would say if you find a locked in inventory, you also hold it and seek a warrant. I mean, that's probably right.
I want to pivot just with my last minute here to pick up on something that Ms. Lucey mentioned that I think suggests perhaps the defendant's position and the state's aren't that far apart. There are clear interpretive principles in some of this court's constitutional decisions. She mentioned Klein, and that's absolutely one of them. If you line up Klein and the factors in the state's brief next to each other, you pretty much get to the same place. Some different words are used, maybe the language is a little bit different, but the principles are the same. We see it in Allen as well, even though the substance or the holding of that case might not be good anymore. And the most important place we see these principles is in Varnum, where this court absolutely showed its work. If you think about the high school kid in math class, it was easy to follow A to B to C where this court was going. That's what the state is asking for in the state constitutional arena.
Is it easy to follow in short? It put out, I think the work we're shown in short, you just don't like the work that was done.
Well, Your Honor, certainly I don't agree with the result in short. I don't think that probably surprises anyone. But I also have questions about how the court got to its decision. The word the court used was persuasiveness. I'm not totally sure what that means. Persuasiveness might mean something like the factors laid out here. These are the principles that go.
But your argument seems a little illogical to me when you say, well, you can't listen to 4 justices of the United States Supreme Court because the 5 are the right ones because that's the law, but we should listen to the dissenting ones in short because that's more persuasive than the majority and adopt the dissenting opinion. It just seems illogical when you frame it that way, and that's how I read your brief.
Your Honor, I see my time has expired, if I might answer. I'm not sure that is what I'm asking, is the court to just wholesale adopt a dissenter's position. I think this is an ongoing important discussion about how we're going to interpret the Iowa Constitution. Short might mean something very close to the 5 principles that I asked for. I'm not sure. It's an evolving jurisprudence. What the state is asking for are clear standards, neutral interpretive principles. Frankly, so I know how to brief these cases on appeal.
You know how to brief the cases. I mean, quite frankly, you briefed it fine. You can look at the language, of course, but the mere fact that the language is nearly identical does not mean there's a strike against the state constitutional interpretation, but you do look at the language. If you can find some history that's germane, as we did in ACOA, some general history, that's perfectly fine. But if you don't find anything, as Tony Amsterdam says, you haven't. I mean, people are still trying to figure out how the Fourth Amendment got framed as it did. Nobody knows, and I've looked, and I can't tell you, and I think we're at the end of the line. Cases from other states, absolutely, and we don't salute them either. I mean, they can be conclusory as heck, and they can be flat wrong, but we'll look for their logic and reason, and we look at the United States Supreme Court cases for logic and reason. Sometimes we might like Justice O'Connor's dissent in Atwater because we think it's right on, and oh boy, that's great, and sometimes not. So you brief that, and then you brief the underlying constitutional values, and we've been talking about that today, I think, in a way that's constructive. But a constitutional brief is not a plea agreement. It's not a checklist. The Constitution is not a tax code. I don't think we can tell you and I don't think you want us to tell you, in some kind of, ukase of what you put in your brief and what you don't. So, anyway,
Unless you have a response, I have a question.
Go ahead, Your Honor. It'll take me off the hot seat for a second.
As you well know, the Supreme Court recently told us that before you can access the contents of a cell phone, you need a search warrant. Compare and contrast a locked safe and a cell phone, and why do you think a locked safe should be entitled to less of an expectation of privacy?
The easy answer for this case, which I know I've already said a couple of times, is that issue isn't in front of us. The policy questions, I think, are really complicated. The rationale about cell phones is that a lot of one's intimate affairs are contained in them, way more than any of the framers would have thought about in 1789. Cell phones are very different from anything that existed then. A safe is close, but I don't think it's quite the same. A cell phone has photographs of a person, a detailed contact list. I mean, frankly, if you took my iPhone, I think you could reconstruct pretty much my entire life easily. A safe, not so much. The privacy interest in a safe is substantially lower than the privacy interest that's in a cell phone. Does that address your question, Your Honor?
It does, but I don't agree with you. I mean, for example, go ahead.
Let me just follow up with a similar type question. Is our struggle in resolving or applying the automobile exception based upon its exigent circumstances going to be mooted out by the presence of our EDMS electronic system and computer in the squad cars that can access and acquire search warrants in 10 or 15 minutes right on the road side of the road there? Are we talking about something that we won't be talking about in a year from now?
I wish I could predict with certainty how technology would change things. I know that right now, the statistic I put in the brief is that a warrant usually takes between 2 and 4 hours to acquire. We could quibble about whether that's true in every case. Maybe it's different for an OWI. I think there will be a point where the warrant preference will be easier to enforce, where the reasonableness analysis under the Fourth Amendment and Article 1, Section 8 might further favor the warrant process. But it's a couple clicks of a button in the officer's squad car. That takes away some of the exigency the state faces. In a case like this one, we're really talking about 3 police officers, one to secure the defendant, one to secure the vehicle, one to go get a warrant. That's 3 police officers taken up Davenport streets in the middle of the night in this case. That's very different from if the officer could hit a couple buttons, it could go to the magistrate and the warrant could pop back to him. I'd ask that this court adopt neutral interpretive principles, set forth clear standards, and affirm the defendant's conviction.
Thank you, counsel. Rebuttal, Ms. Lucey.
Could I ask you a question? Are you arguing here that we not recognize an automobile exception any longer under the Iowa Constitution, or are you arguing for a safe exception under the Iowa Constitution to the automobile exception?
I am arguing that there should not be the automatic automobile exception, that if it is an automobile, that immediately has the exigent circumstances covered, because that is not necessarily logical. If the person cannot drive that vehicle away, it doesn't have that mobility. I'm also arguing that the automobile exception as adopted by the U.S. Supreme Court is not compatible with the Iowa Constitution. I would submit that I have no lesser expectation of privacy in my vehicle where I have hidden things from plain view than I do in my home.
Well, am I hearing you correctly that you think that we need to have this independent, separate and independent and additional factor of exigency to the automobile exception? Is that what I'm hearing?
I think we should stop calling it an automobile exception and start calling it exigent circumstances, where the automobile is one factor.
And along that line, what other authority or jurisdictions have this type of setup where we have this separate and distinct exigency factor?
I have them listed in my brief. There is, I just have to get to it, New Jersey, of course, now I'm not going to find it, New Jersey,
Washington, Vermont, New
Washington,
Hampshire.
Vermont,
Nevada.
New Mexico, I think maybe Nevada. And those are just the ones that I found, where they say that the rationale in Carroll is not compelling.
Could you play out the practical consequences if we say you have to get a warrant in more of these automobile cases? Doesn't that mean that instead of a quick search, nothing found, citizen is on the way, citizen may be held on the side of the road for as long as it takes to get a warrant?
I think that's a balance, because let's face it, things that are bright line rules aren't supposed to be that, it's easy for law enforcement. It's the Constitution. And whether the Constitution permits something that's easy for law enforcement shouldn't be the factor. I was sort of surprised by Professor Kerr's analysis about this equilibrium shift, that there's lesser degrees of protection under the Fourth Amendment when things get hard for cops. I don't think I'd buy that, and I hope that this court does not buy that.
I think what I'm hearing you saying, and maybe I'm wrong, but that there has to be a real exigency. I mean, all automobiles don't create an exigency, and that's all you're asking us to look at under the Iowa Constitution, as these other states do.
That's it.
And that's it. And you don't want a blanket bright line rule that if you stop a car, you get searched the whole thing if you have probable cause, because cars are mobile.
Correct.
And I think in today's society, that came from the ships at sea, and
Correct.
they were surely mobile, but it's different today, I think.
And horses and carriages where you saw what you could see. I carry my briefcase in my car, and if I stop at the grocery store, you better believe I lock it in my trunk, because I really don't want people looking through it, because I have confidential information in there. I think that there has to be some balance to say that we have no expectation of privacy in our vehicles. And we
True, I mean, you seem to be agreeing this rule will lead to less clarity in the law, right?
I don't think it will lead to less clarity. I think it will lead to the idea that you need to actually have an analysis, instead of you get stopped by the police because you're speeding and they find out you have a warrant for an unpaid parking ticket. You get arrested and they get to search your car, because there might be other unpaid tickets in there. And that goes back to the whole Gantt analysis. The state submits that Gantt is really probable cause of accident circumstances. Well, if that's the case, then why do we need a second prong? We don't need a second prong for reasonable to believe.
Could you address the cell phone issue?
The cell phone issue is actually an interesting case, where the majority basically says, because of the incredible amounts of private information that cell phone can contain, we just don't think it's like other containers. Scalia has an interesting concurrence in that, which basically, I think he's sort of questioning, it's Justice Alito who's questioning, again, this reasonable cause to believe in Gantt that's left unanswered. That was the interesting part. I think they got it right in Riley, that there is an expectation of privacy in your cell phone. I have an iPhone now. I can guarantee you, if you look at my iPhone, you're probably not going to see my life, because I use email, text, phone. I don't have, Facebook and all of that sort of thing. But I don't want people looking at my iPhone and seeing my email to my mom. I don't think that's any of their business. And there should be some basis that you should actually get to look at that.
Well, the real question, I think, is if a cell phone was in the front seat of the car and the car was seized through the automobile exception, could you look in the cell phone?
In old cases, the answer was yes.
Yeah, and now the answer is?
No. And I briefed that under the Iowa Constitution several years ago, And I looked at the cases and they equated it to a beeper. And it's not like a beeper. You know, then we have the whole regulatory issue of, you know, cars and airports and all of those sort of things. An average car does not have that type of regulatory issues.
So the safe isn't a huge safe, and this one, in this case, obviously, probably contained likely less information than your cell phone. Does that entitle it to less protection?
No. No. I mean, I have a safe that I'm guessing looks very similar to this safe. Mine's not fireproof. Things that I have in that, I don't think it's any of the officer's business to look at it, even if I had a joint or a blunt. It has nothing to do with.
But you agree there is probable cause to seize the safe?
Actually, in this case, I would say no, there's not probable cause to seize the safe, because